Hey folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And today again we'll be continuing with the prevention of operation and mismanagement. Right? So when we talk about operation, right? So we in the previous lecture have already discussed section 397, right? That dealt with not only operation but also the conditions that have to be fulfilled if you want to claim some relief from that operation, right? So what is operation? Or when would it result to an operation where a minority could go ahead to claim relief? There were 5 points over there. First, that there should be some lack of probity or some lack of fair dealing with the public. It should be oppressive or prejudice to the public interest. Second, it should be in the capacity of a member. So who is being oppressed is the member. Then oppression should also be a continuous process. There are two things over here. Either the minority is continuously being oppressed, or there has been a decision or a judgment or an action taken by the majority that occurred only once, but the effect is continuous on the minority. Even that would result to oppression, right? Third, oppression should be so severe that it should be a just and equitable cause for winding up the entire company. But winding up could not be possible. Why? Because that would again be prejudicial to the interest of the applicant itself. You remember we talked about the concept that operation basically is an alternate to winding up, where you cannot wind up because of certain situation, that if you wind up, then the winding up would be prejudicial to the applicant itself. So in that case, the alternative is oppression or relief from oppression, right? So in the previous lecture, we went very haywire with the entire concept because we went into the detail and overlapping understanding about the same and the other concept. So today what we will do in this lecture is take up the case studies, right? So when we are discussing the case studies, we bang on to any individual point and understand that, right? So your entire previous lecture will be refreshed and will be seeped down into your brain when we go ahead with the understanding of the case studies that we have. On for it? So the case studies. The first case study that we have is a situation where there's a company, right? The company's name is AB Limited, and that company is formed by two groups, two different groups. And the two groups are Alpha and the Beta group. Now, both of these groups have their shareholding in the company in the ratio of 60 is to 40. So 60% share is held by Alpha and 40% share is held by Beta, which means Alpha is the majority and Beta is the minority, right? But both of them, they share equal managerial power. What does that mean? Which means that whatever decision has to be taken in the company, it has to be taken by the consent of both the groups. If any one of them deny, so it's 50-50%, right? If any one of them deny, it will be a deadlock. Either both will say no or both will say yes, only then an action will be taken, right? And now there's a situation where there actually arose a deadlock, where Alpha group says something else and the Beta group says something else, right? But now, since if you look at the shareholding pattern, Beta group was the minority. So what did the Beta group do is that Beta group went ahead to claim relief from the company law board, saying that listen, we have 40% of share, so Alpha Limited is trying to impose upon certain restrictions on us, which will result into oppression, right? So this is the entire case, and now we have to understand the outcome of the same case, right? So there are two things that we need to understand over here. First, is this actually operation? Will this claim be tenable? Will it be sought for? And second, what will be the role of company law board? Right? What are the actions that the company law board can take in this situation? So understand one thing, that both of the groups are equally strong, right? And second thing you need to understand is that a relief from operation under section 397 is not available if the case is not severe enough to wind up a company. Understanding? So if you look at the case study now, do you feel that all the 5 conditions that we had talked about are fulfilled over here? The first condition, it is oppressive to the members and it is prejudicial to the interest of the public. So over here we don't see any prejudicial public interest, right? Second, operation should be continuous. Third, it should be a just and equitable cause of winding up. And winding up should be prejudicial to the minority, right? An operation can be claimed only as members. So there are one or two things that are okay. That means, yeah, they are members, so they can claim, right? But it is not a just and equitable cause to wind up the company. Right? It's just a deadlock. It is not operation. So that's the contention of Beta Limited, that the Alpha Limited is trying to oppress the Beta Limited, will not be tenable. Right? Now, next thing what we need to see is what will be the role of the company law board. So understand, the power of the company law board is discretionary in the nature. So over here, when there's a deadlock and the case has gone to the company law board and there is no cause of operation, right? Then what will the company law board do now to resolve the situation? Although there is no operation, the situation has to be resolved, right? So the company law board will ask both the groups to take over the share of each other. So the company law board will ask Alpha Limited to purchase the shares of Beta Limited if they want, and Beta Limited if you want to sell, so that Alpha Limited can go ahead with what they want to do. On the other hand, the Beta Limited can go ahead with what they want to do if Beta Limited purchases the shares of Alpha Limited. That means the company law board can try to split the company and leave the entire thing with one single group. That is possible. But since it's a deadlock and both of them are either not in the capacity to purchase the share or do not want to purchase the share, means to conclude the shares cannot be purchased or transferred, right? Then only one thing can be done. What? It's wind up. Because over here they'll have again a just and equitable cause. That the company has reached a deadlock and the company is no more operative. It cannot operate, right? So the company law board is trying to get the company into operation by just breaking the deadlock. But the deadlock cannot be broken. Hence the CLB may be in a position to order for winding up of the company because the alternate is not possible over here. Right? That is case study number 1. Next. Now there are two family groups. One group had 4 directors into the company, A, B, C, D, right? And the other had just 2 directors, G and H. Now what happened is the first group, or the first family group who had 4 directors, they passed on a resolution for removing the other 2 directors. Right? Because if they had 4 directors means they have majority members also, it is deemed, right? Because now you see there are just 6 people over there. So they pass a resolution to remove the other 2 directors, which are G and H. So let us see what happens in this situation. So the first group who has removed the 2 directors from the second group, that is G and H, right, has taken an action. Now G and H, that means the second group, now they try to defend themselves. But since they do not have any position in the company, they are not the majority, they cannot take any action. So they plan to approach the company law board for that. And they charge the first group, that is ABCD, for oppression. So they file a petition to company law board to claim relief of oppression. Now the company law board will get into detailed analysis as per section 399 and 397. So as per 399, first thing that they will check is the requirement of claiming relief, right? Who would file the petition? Because the government will not entertain or will not enter into the management of any company. But over here, since there's a situation and they are trying to file a petition, they will enter. But for that, as per section 399, right, in the case of a company that has share capital, at least 100 members are required to file the petition. If the company do not have 100 members, then 1/10 of the total number of members. So where if there's 6, then 1/10, that is 0.6, means even one member can file the petition. Members holding not less than 1/10 of the issued share capital of the company. So these two are well in a position to get ahead with filing up the petition. But it is not a share limited company. This company does not have share capital. So the company that does not have share capital, in that company as per 399, at least 1/5 of the total number of members are required to file the petition, right? But will that petition actually be entertained is the question. So in the present case, the removal of 2 directors cannot ipso facto amount to an act of operation. Why? Because there are certain reasons. Now let us check all the 5 points that we had, right? The first, the election and removal of directors is a prerogative to the members. and such an act cannot ipso facto be treated as oppression on minority unless the conduct of the majority is based on malified considerations. Right? That means unless and until the intention of the first group is malified, right? This is a normal act that could be done by the management, and hence there is no problem with that, right? Second, if it is to be considered to be an oppression, then there has to be some act which is very burdensome, right? Which is harsh and which is wrongful. So oppression involves an element of lack of probity and fair dealing also, right? So over here in this situation, if you see, then mere removal of the two directors does not amount to oppression in any case, right? The third point that we need to check is that for claiming relief from oppression, you have to be a member. Over here, you are a director, right? So as a director of the company, you are outside the purview of section 397, right? Second, you can claim relief from oppression only when the act that you have complained of is so severe that it would result to the winding up of the company. So over here, do you think it is just and equitable to wind up the company? The answer is no. And do you think the operation is continuous in this situation? Again, the answer is no. In the given case, it's been made very clear, right, that it is not a result of operation, right? So, because if you look at the conditions of 397, none of them are satisfied. So, if there is no operation, there is no relief that can be claimed from the company law board. Getting the point? Although the directors are removed, but that is an ordinary course of business. Does not result to winding up. It is not occurring in capacity of a member. Is not harsh or wrongful or burdensome. Whatever be the intention or otherwise what they have done is as per law, right? So in this situation, operation will not keep up. So understand friends, there is a very thin line difference that lies, right? So you have to check all the factors. And to answer the question in this chapter, the only information from this chapter is not enough. You'll have to have an overall understanding of the entire company law, right? You'll have to understand what are situations of winding up. So we have already covered the chapter of winding up. So all of you who have prepared themselves with the winding up chapter already will know what are the situations for winding up, right? Similarly, the other aspects also, what is burdensome, what is not, what is in the ordinary course, what section says what, these all things have to be there on the tips in order to be able to perfectly answer the questions in this chapter, right? The next case study that we have. So there were three brothers, A, B, and C, and they had equal share in the company, right? So it was again a family-owned business. Three brothers, A, B, C, having equal share means 33, 33, 33 percentage, right? But now what happened? There was a conflict between A, B, and C. So A, B on one side, C on the other. So A and B, what did they do? Is since they had 66% share, they assumed all the powers. And since they were a majority, they increased the shares in their end, right? And because of their increase into the share at their own self, like shares increased only with B and A. And the meeting that they conducted for that, in that meeting, they did not invite C, right? So at the end, after they have increased their shareholding in the company, what was the percentage that turns out is 45, 45, and 10, right? And remember, for that particular meeting, there was no notice that was sent to C, right? So what relief does C have, right? Can C claim relief against oppression from the company law board and the government? Is something that we need to check now. So guys, if we get into the case and understand, right, then two people, that means two brothers A and B, are trying to make advantage of their having 66% share. So what they do is they hold a meeting and do not invite C, and then pass a resolution to increase their own shareholding, and hence gaining a special majority over there, 90% shares, right? So now whatever they do in future, they can do it by themselves, and C will have no say, right? So in this situation, if we go ahead and understand and analyze whether C will be able to claim relief of operation, then there are certain things we need to see. First, what is the action that has been taken? The action that has been taken is to increase the shares of the company, right? Now we need to see whether company required this, or is it being done in favor of the company? Will company be benefited out of it? The answer is we don't know because nothing of that sort has been specified in the question. So let's assume the company did not need it. Why? Because we can see that their intention was to increase just for the sake of holding more shares. So it was not an intention to facilitate the company with the increase in share, right? Second, if you increase the share, right? Why? So that one person or one group can have some advantage, some benefit out of it, and the other and this increase in share would be detrimental to the other, right? If this situation takes place, then it is wrong, right? Why? Because one group is trying to take an advantage of the position that they are in. So in this situation, we can say, yeah, they are trying to take advantage of the situation, of the position also, right? Because that is a clear intention. Their intention is to take or reap benefit, right? And that will result to detrimental position of C. Second, the company does not need the increase in share at this point of time, so they're not doing it for company, right? Third, they are doing it just to hold some more power. They are trying to acquire more share to have control over the affairs of the company. Even that is wrong and prejudicial, right? So this would result into oppression, right? Further, if we go on to check, right, then they were existing majority, right, and they are trying to submiss the minority. Although this is a single act, the act lies in isolation, but this act will have ripple effects in future. Why? Because they have increased their shares and this will have a continuous effect even in future because C is left with only 10% of shares instead of 33.33. Getting the point? So it is continuous also. So first it is harsh and burdensome on C. Second, it is continuous. Third, C is a member. So three conditions have already been satisfied. Right? Moreover, since company did not require it, right, and these situations are going on and it is unjust to do that, you can also say that it is just and equitable to wind up the company and distribute the shares among them. But this winding up would be prejudicial. Why? Because if you go ahead to wind up the company, C would receive only 10% of the proceedings. So all the five conditions of operation are satisfied in this case. Hence, C will be eligible to claim relief. Right? Winding up also is why winding up also is very much possible is because when they are conducting the meeting also they did not send the notice to C. Right? That means the operations that are being conducted in the company are not being conducted as they are supposed to be. They are not following the law and regulation. Right? So there are a lot of reasons why A and B are at fault in the situation and C should be given the relief from the oppression. So company law board will take charge and provide relief to C from that operation. Right? This is how you actually check and evaluate all the different cases. Five core things in operation has to be checked, right? Crystal clear with you. The next, share allotment. So there has been a situation, like let us refer to a certain situation. So there's a situation of allotment of share, but when the shares are allotted, there is a shift in the holding where the majority turns into minority. Why? Because the other, that is the minority, has been given a lot many shares to become a majority now. And the other situation could be where the minority turns majority. So in both the situation, actually the same things are taking place. Getting the point? Either the majority turns minority or the minority turns majority. It is actually a flip in both the situations. So what actions have to be taken are something we need to see now. So again, when there is a situation of allotment of shares, right, what we basically need to see is whether share allotment was required by the company's end, right? So in this situation, like if you refer to the previous case also, now it is case specific, right? So if the directors, they are trying to allot shares so that one of the group, right, they gain some benefit out of it and it is detrimental to the other group. If that is the situation, then it's wrong. Right? Plus, if the shares are allotted unnecessarily and the company did not need any more share allotment at this point of time, it is again wrong and would result to oppression. Right? Plus, if it is done so that one particular group may gain some extra position or an authority over the affairs of the company or control over the affairs of the company, then again it would result to operation. Right? So it is similar to the situation that we have seen in the previous case, right? So if the majority is turning minority due to the allotment of the share, right, then it is oppressive to them because they are members, first of all. Second, it is burdensome and harsh because they had a controlling interest in the company which is taken away from them. Third, if you try and understand, then company did not need it. Right? So this act was not required. It would also result into winding up of the company. But if you wind up, then again, due to the change in the shares, it would be prejudicial to the applicant. Right? So all the conditions, all those five conditions are satisfied. Right? Therefore, allotment of shares by the directors of the company by which the existing majority is reduced to minority shall amount to operation if the directors have acted mala fide. Right? If they have not acted mala fide, if everything was bona fide, then there was no problem. Right? In the second situation again, if the allotment of shares by the directors by which the existing minority shareholders are made majority shall amount to operation if the directors acted mala fide again. But if the intention was very clear, if they were acting bona fide and still something like that happened, then the situation is out of control. Right? There was one more case that I haven't specified over here, right? But I think we need to know about it also. Now what happened that there was an agreement which was executed by some NRI, right? The NRI, what did they do? That he handed over the agreement to an escrow agent. That escrow agent was supposed to now take ahead the entire purchase of the share, right? So the sale was subject to RBI's permission. Why? Because it was an NRI involved, right? But RBI's permission could not be taken for a period of elongated period of 6 years, and hence the share was not transferred for 6 years, right? Then the NRI person who waited for 6 years period, right? He raised an issue and complaint regarding the operation in the capacity of member, right? As per the agreement, the sale was unconditional, although it was subject to RBI's permission, right? So during the above period, the NRI did not exercise any right as shareholder, nor did the company treat him as a member because the share was not transferred. They were waiting for RBI to give the permission so that the share could be transferred to the NRI, right? So what is it that the NRI could do in the particular case, right? So understand the sale agreement was executed by the NRI, right? But the script was transferred to the escrow agent and it was subject to the permission of RBI, right? But the full consideration of money was received. But after the lapse of this long period, right, you cannot raise an issue of operation in the capacity of member, right? Why? Because the transfer that was supposed to happen that remained in abeyance, awaiting RBI's permission. Right? So, so on the fact the sale of shares was unconditional and unrestricted, and there was no clause to render the sale agreement infractious after lapse of an stipulated time. So if you see the operation also that has happened to him, it is not continuous now. It's been 6 years. 6 years back he had executed a sales deed, passed it on to an agent, but that could not be completed. Right? So also during the long intervening period, neither the NRI exercised any power as a member of the company, nor the company treated that person as a member. Right? So therefore, it is said that there is no operation. First of all, why? Because the NRI is not a member at all. Right? Second, this will not result to winding up of the company. Why will it? It is just an agreement that is to be taken forward. RBI did not give permission. The agreement was not executed. So he's not a member, the agreement could not be executed, no result of winding up, no prejudicial effect, it is not harsh, not burdensome, and it is not continuous as well. So all the five conditions of operation is not being fulfilled over here. Hence it is not operation. Right? Now here's the last case study. So A and B are directors and major shareholders of the company too. C is the chairman of the company already and a minor shareholding. So what A and B decide is to issue further share, and this has been decided in consultation with C. But if you look at the situation, what happened basically is A and B, they do not have more money to purchase more shares, but C has plenty of money stored. So whatever shares they're planning to issue, C is in a position to take up all the shares. And if C purchases all those shares, she would turn into majority and A and B would rather turn into a minority. So what did A do? A and B, they passed a resolution to give the shares to the outsider instead of C. So if they pass a resolution that all the shares that they are issuing will be sold to the outside people, right, 12, 15 more members from outside, then obviously C is not in a position to buy them. And hence the majority shares will remain majority with A and B. C will not come into power. Now C got offended and C planned to raise a petition against the company to the CLB, right, and to claim relief from oppression. Now this is a situation that we need to understand. Is it oppression? So first, if it's an oppression, right, then the majority should be doing something where there is lack of probity, where there is unfair conduct, and which is prejudicial or detrimental to the public interest also, right? So do you think merely an inclusion of a clause that the shares will be sold but will be sold to an outside agent, is that detrimental? Is that defeating law in any point of time? The answer is no, right? So there is no conduct of any majority that is trying to suppress the minority. No, they're just trying to get into a legal settlement that okay, we are issuing shares, let us issue shares outside, which is very much legal, right? So if the law decides something and as per law you're doing something, there is no problem with that, right? So if you're seeking change in the management, why change in the management? Because there are more people coming in. Then prima facie, it does not tantamount to oppression, right? And if we refer to the provision of section 81, 1A of the Act, it is permissible for a company to offer the further issue of shares to any person other than the existing shareholder by passing a special resolution. So whatever A and B has done, they have done in their capacity and they have done holding the power and as per section 81 1A of the Companies Act. So they haven't done anything wrong. There is no oppression, there is no hardship, there is no lack of probity, there is no case of winding up, there is no case of alternates to winding up, there is no oppression to members. Hence, if none of the 5 conditions are satisfied, this will not result into oppression. Right? So now I think you understood how do you identify whether a situation results to oppression or whether a situation will not result to oppression. Right? So although we have had a lot of discussions in the previous 2 lectures, like the last lecture and this lecture, but still those 5 key points remain same. We have analyzed it from different angles, from different cases, but they remain same. Right? So just check those 5 situations, and for checking those 5 situations, you have to be knowledgeable enough in the law. So this chapter cannot be done in isolation. When you have done the entire company's law, this chapter will start making more sense. Right? So anybody who hasn't completed the company law and still going through this chapter, maybe you'll find some difficulty in understanding, but that's okay. Right? You have had other lectures also where the understanding was crisp. Over here, the understanding may be a little difficult, but it is just because you will need to have an entire knowledge of the company's law in order to grab an understanding of this chapter. Right? So that will be all for the day. I'll see you guys back in the next lecture. Until then, this is Abhinay Gupta signing off. Thank you and bye-bye.